because I didn't want to get in a situation in the middle of this examination that we couldn't turn off the live chat. All right, we're back up. We're running, and the live stream is back on. The chat is off. I apologize, I interrupted you, but I was having trouble cross-referencing each of the references in the DNA, and your representation that his clothing was covered with DNA. I certainly didn't see that in the pictures. Maybe the shoes, but all right, I'll let you finish and then we'll hear from Mr. Weesey.
And again, I think that when we are looking at the lab report, the shoe, you can see it, the pants, when you look at people's exhibits of the pants, there's some sort of staining that's present on the pant that's visible to the naked eye. I indicated that I do not believe there's anything to the naked eye that's present on the shirt. However, it was revealed in the MSP lab report number 3 through their testing that there was potential DNA on there as well. And then again, the glasses, you can see a couple of spots of blood on the photos that the people have submitted. And then again, in lab report 3, it indicated that there was the possible presence of blood, and the testing did come back with that being the DNA for Mr. Schwartz. So when I'm saying that the DNA is all over, I don't want to misrepresent by saying he's covered head to toe in someone else's blood in terms of there's no skin visible or anything like that, but that on each of these pieces of clothing that he's wearing and also the items that were discovered on his person, that they do go back to having both, some of them, both his DNA as well as Mr. Schwartz's DNA, and some of them, such as shoes, only Mr. Schwartz's DNA, which goes to contradict then the statement that he didn't touch him, he didn't render aid, anything along those lines. He in fact was there, present, covered in his blood when he's bleeding from this laceration to the back of his head, which gives probable cause that he's the individual who did this.
Well, his fingernails are described as 19714212D and a fingernail swab 12E. Was any blood found on Mr. Dingman's hands or in his fingernail swabs?
The fingernail swabs, I believe, if you go back and you look at exhibit 13, it's not clear in here. My understanding, those fingernail swabs, though, if you look at the pathology report, so People's Exhibit 1 from Dr. DeYoung, she took fingernails clippings of the victim, Mr. Schwartz, and those were submitted for testing for the purposes of DNA. Those are the fingernail clippings that were then tested here. That was not one of the things that we stipulated to or talked to in this report, but my understanding is there was no fingernail clippings with Mr. Dingman. That's not in evidence, but what is in evidence is that fingernail clippings were taken from Mr. Schwartz. Those are the fingernails that then were processed in People's Exhibit 13 and 14 and that do not come back and show any DNA. So it's not Mr. Dingman's fingernail clippings, it's Mr. Schwartz's fingernail clippings. And in People's Exhibit 1, it's page 8 of 8, about, the very last item, it's the 4th bullet point.
There was testimony from Deputy Hughes that he took swabs of the defendant's hands and with distilled swabs. There's no evidence here in this record regarding any evidence from the person of Mr. Dingman.
That's correct.
All right, I'll let you finish.
I believe that I already concluded requesting bind over, Your Honor.
All right. Mr. Weesey?
Thank you very much, Your Honor. First and foremost, I would move, Your Honor, to strike or to not to consider any statement provided by Mr. Dingman, and that includes anything from his initial interview with Chief Freakert right on through what I believe would have been the fourth statement to the two detectives at the county complex. The testimony from Trooper Bourgeois was that Mr. Dingman approached her and she directed him to stay at Chief Freakert's car. Chief Freakert then says, yes, he's at my car. I put him in my car. Amazingly, Chief Freakert testified, he's in my car for mere moments after I had been in the crime scene for 3 minutes. Doesn't make really incriminating statements. And the chief steps out of the car, goes back to the officers and says, I've got my suspect. I'm not 110% sure, but I have my suspect. That leads to Mr. Dingman being detained even longer and now in the backseat of the officer's car where he's not free to leave. And at no point in time at any of law enforcement's interactions with Mr. Dingman do they Mirandize him. Do they tell him he's free to leave? Do they ask him if he wants to leave? Do they ask him if he consents to questioning? There's just nothing. Nothing at all. It's just, well, he didn't say anything, and so we assume he's just consented to these voluntary conversations. And the chief even said, well, yeah, he's in custody. When I pressed him at, and I believe it was the second interaction with Mr. Dingman. Certainly, by the time we get to the jail, or the administrative side of the county complex, for the fourth interview, after being moved from the scene, the idea that Freakert is going to make the decision that this is all voluntary is troubling on its face. And I would ask, Your Honor, to find a Miranda violation at every step of the way and not consider anything that Mr. Dingman set forth. Even if Your Honor doesn't go there, as the court's already stated, many of the statements were exculpatory. And it seems what the prosecutor is trying to do is cut and paste some inconsistencies and try to equate that to probable cause, when the record is clear that the officers who interviewed Mr. Dingman were concerned about his mental health. The record is clear. Every step of the way, he is just throwing things out there out of left field that make absolutely no sense. Reasonable inference, I mean, can you really believe anything this person is saying? Even if it is somehow woven into some sort of an incriminating posture. And even if it is that, don't we have sort of a corpus delicti problem here of considering these statements? Even if there's no Miranda warning, and even if there's inconsistent, I mean, where are we going to go with that? And even then,
Well,
and I know you're not a jury, but there are just countless.
Describe further your corpus delicti problem. We certainly have evidence that a crime was committed. even from first initial viewing of it, the person's laying there and there's blood all over. What was your reference regarding lack of corpus delicti?
Well, we have probable, I would concede that there's probable cause. The doctor did testify that it was her opinion that there's probable cause that the death was caused at the hand of another. You know, I suppose it could have been self-defense. I suppose it could have been any number of things, but for the purposes of exam, I would retract that argument.
All right, thank you.
But what we also know, Your Honor, and it's unfortunate that we didn't have the 911 call on the record here today. The only inference we have, or the only testimony we have, is that Ethan evidently made the 911 call. The trooper said, "Hey, I've got the caller here," and the chief's characterization of his being dispatched out there, I believe he described it as a medical. I was dispatched to a medical. So reasonable inferences there could certainly explain any type of physical evidence that may exist. We have somebody who found a body and called 911. That's what we have here. That's what we have here. And they're trying to weave this, well, he said he didn't want to touch it, and they're trying to weave this banana, and that equates to a murder. And that's thinner than thin, Your Honor. When the government spends more of their time talking about the forensic pathologist, that leads me, okay, we have a death, which is tragic and unfortunate, but the record here is painfully lacking with respect to probable cause as to who may have done it. It's certainly lacking as to whether any indication that Mr. Dingman played a hand in the actual death of Mr. Schwartz. So I would oppose the bind over for lack of probable cause, and I would really tempt Your Honor to go through an analysis on those statements with respect to custodial interrogation.
Any rebuttal?
Yes, briefly, Your Honor. First, in regards to Mr. Dingman's statement, they were not a violation of Miranda. The police certainly have the ability to conduct an investigatory interrogation of an individual short of a custodial interrogation. I mean, that's common constitutional law that we all understand. We're used to it, maybe more in the drunk driving context or in other contexts, but certainly if they have reasonable suspicion that criminal activity is afoot, they have the opportunity to detain Mr. Dingman for the purpose of confirming or dispelling that suspicion without triggering the need for Miranda to be invoked. That's what happened here. That's what was discussed throughout the course, both in terms of with Chief Brinkert, but then also with Mr. Dingman, Mr. Dingman's participation at the sheriff's office. But even if we don't take into consideration Mr. Dingman's statement, what we know is that Mr. Schwartz did not walk up and leave that garage that day. Yet from that pool of blood, there is footprints found in the ground. We see on Mr. Dingman's shoes the blood of Mr. Todd Schwartz, but the blood is not limited to his shoes. He didn't just wander in there. It's on his pants, it's on his shirt, it's on a pair of glasses that belong to Mr. Schwartz that we have in People's Exhibit 2. We see him wearing them. The DNA is found on there as well. And it's not like it's just some random touch DNA. You can see on the glasses that there's blood on those glasses as well. It's also on Mr. Dingman's shirt. He has Mr. Schwartz's blood, the blood that was the result of an intentionally inflicted injury on his person. For the purposes of a preliminary examination and a probable cause determination, that evidence is sufficient, and we request that you would find the matter over to circuit court.
All right. I had hoped also to hear some evidence of footprint matching from the footprints in the garage to the shoes of the defendant. And I don't know whether that exists, or if it does, what the status of it is. I'm very concerned about the admissibility of the statements once Mr. Dingman is put in the back of the patrol car. Voluntariness is in the eyes of the the holder. Suppose to call it voluntary doesn't make it voluntary. The defendant is obviously struggling with mental health problems, and it was apparent to everybody who was dealing with him at that point. There was no evidence that he was covered in blood or had blood on his hands or face or obvious blood in his possession. He was put in the car, apparently didn't leave blood all over the car. There's apparently, if there is any evidence of blood on his hands, it's not in this record. And Mr. Weesey alleges that he's a guy who was mentally ill, found a body and called 911. The next thing he knew, he was in custody, not well able to articulate his point of view. Clearly, once he asked for his attorney, any questioning after that point is almost black letter. Unfortunately, the entire interview conducted with the defendant at the sheriff's department is not recorded, which makes it almost worthless. Mr. Weesey's correct. I need to take a closer look at the timelines of each interrogation and determine, certainly that I think the first questioning by Chief Brinkert, obviously the guy found the body or he wouldn't have called it in. He didn't run away. He didn't hide. He walked next door to the Shell station and called 911. Apparently, within a brief time of when he saw the body. So there's a lot of unknowns here. The prosecutor's case rests on the fact that the defendant said, I didn't do anything. I didn't want to touch the body. I didn't want to get blood all over. So I want to look at the forensic report more carefully, and I want to dissect the different interviews. It appears to me that in the report there are some other DNA contributors that are not accounted for. And that's troubling to me. So I need to make sure I understand that. So is everybody available tomorrow morning at 10 o'clock?
Your Honor, I am not. I have a hearing in Grand Rapids. I can be available 11:30.
How's your afternoon?
I'll make myself available.
All right, can we reconvene at 1 o'clock?
Yes, Your Honor.
Yes.
All right, I'm going to carefully review the testimony. As conceded, the first prong of this was this a homicide is not difficult. There's certainly probable cause that there was a killing under unjustified circumstances. The question is there enough admissible evidence to raise it to a level of probable cause that this defendant did it? And that's a very low standard, Mr. Dingman. It's certainly a lot lower than proof beyond a reasonable doubt. Probable cause is even less than a preponderance of evidence. In the scheme of evidence, at 0 is no evidence, and at 100% is absolute evidence. Well, we never get that. There are different standards. One is reasonable suspicion. That's down here in, I don't know, the 15% range. Then there's a preponderance, which means more than half, 51%. That's the standard in a civil case. To prevail in a civil case, you have to prevail beyond a preponderance of evidence, which is 51%. To convict somebody at a jury trial beyond a reasonable doubt is a difficult standard to meet. It's up closer to the 100% end. Well, the probable cause standard for a preliminary examination is somewhere between reasonable suspicion and preponderance of evidence. It's less than 50% and maybe more than 15%. It's a probable cause to believe that something would have occurred. And there's no hard and fast formula on what is probable cause. You have to view it in light of all the circumstances. So the standard is not very high to find probable cause, but I have a concern that even that standard has not been met here. So we will resume tomorrow at 1 o'clock. I will carefully review the testimony, and I want to cross-reference the DNA reports. And I didn't have very much time to read them. I finished at noon, I worked through lunch, and then we started right at 1 o'clock. So I'm gonna have to chart these out, but I'll have enough time to do that. All right, we'll resume tomorrow at 1 o'clock. Anybody is welcome to either come back in, Mrs. Dingman or Officer Males, or simply go on the YouTube feed. Same with you, you're all welcome to come back tomorrow at 1 or log in at the number the prosecutor will give you, or just watch it on the feed. But I want to do some careful analysis of this. It's a very important decision. All right, anything else we should place on the record?
Thank you, Your Honor.
Your Honor, thank you very much for your time and consideration, and it is serious, and we appreciate it. Ms. Shepard and I do have one more stipulation, and that's Judge Pattison clearly owes you at least one lunch, if not two, for having to get involved in this file, and we're not talking about hot now either, Your Honor.
All right, well, it is what it is, and I'll try to do the best I can, and I will see you all tomorrow at 1 o'clock.
Thank you very much.
All right, thank you. Mr. Dingman, we'll have you brought up again tomorrow at 1. All right, we're going to end the